What are your rights if your landlord wants to convert your building to a condo, right? and to a large extent, the answers I'm going to give are the same if your landlord wants to convert your building to a co-op, right? Um, but let me just sort of quickly uh, just touch on like what is a condo, right? Condo is it's a form of ownership, right? And I'll kind of sort of talk a little bit about that. Um, but the New York State securities law, right, which is also known as the Martin Act, right? The New York State securities law is what created condominiums here in New York, right? And a condominium is the ability to own your respective apartment within a building, right? That's what a condo is. You own your actual apartment within a building. You get a deed, right? Like if you own a house, you would get a deed for your property, meaning your apartment, and that's different than a co-op, right? A co-op is a collective form of ownership where everybody together in a building owns what's called stock, right, in a corporation, and that corporation owns the building. So you're actually like a partial owner of the building, and you also then get what's called a proprietary lease or a lease for your particular apartment. Your shares of the corporation correspond to your apartment. So it is a different. Condos and co-ops are not the same. They're different. They're both structures that allow private ownership of multiple dwellings, right? Multiple units within a building, but they are not the same. So with regards to condos specifically, you get news, you're a tenant, you get news that the landlord wants to convert your building to a condo or a co-op, and you're sort of confronted with, oh my goodness, what does this mean for me? And that's a very, very easy question to answer, right? So I think the first thing to know is that most conversion plans and all conversion plans have to be approved by the Attorney General, right? That's the Attorney General for the state of New York. That person right now is Letitia James. So the owner would have to apply to convert the building to condo ownership. And what that means is that, and this was a big change, it used to be 15% of the tenants in occupancy would have to purchase, right? So again, this is an owner coming around and saying, I want to change how this building is owned, and I want to provide you an opportunity to purchase your apartment. And almost always they'll do that at what's called an insider price, right? Where they'll give you a price to purchase your apartment that's less than what the market would bear, to sort of incentivize you to buy. And prior to the HSTPA is the Housing Stability Tenant Protection Act. That was in 2019. A landlord only needed 15% of tenants in occupancy to purchase in order to convert, right? A relatively small percentage. And the HSTPA turned that on its head, and the HSTPA requires now 51%, right? So a majority of tenants in occupancy would have to agree to purchase their apartments before a building owner could convert the building to condo ownership. And what we saw following the HSTPA is that very, very, very few condo conversions were happening, right? And very well, that could have been the purpose of that act, right? To the HSTPA, that provision of the HSTPA, right, was to limit the number of condo co-op conversions, the condo conversions going on in New York City. So the question though becomes, what if you're a tenant in a building and you have no interest in purchasing your apartment, but the building is going to convert to a condo, right? Or a co-op? What are your rights, right? So under the Martin Act, most conversion plans are what's called non-eviction plans, right? Meaning they're not seeking to evict tenants in occupancy from continuing to reside in their apartments. It's really hard to get approved an eviction plan conversion, right? Eviction plan conversion would be where the owner is seeking to get rid of tenants in occupancy, and those are very, very, very difficult to get approved, right? For obvious reasons. So almost always the conversions are what's called non-eviction plans, right? Where you provide um, essentially you provide guarantees that any tenant in occupancy will continue, right? And if you're a rent stabilized tenant in a building and your building is going to convert to condo or co-op ownership, you do not have to buy and you will not lose your rent stabilization rights, right? So that's the biggest sort of takeaway right there. So if you're a regulated tenant, if you're a protected tenant, and your owner is seeking to convert your building, you don't need to be that's not a basis to remove your apartment from rent stabilization. It's not a basis to evict you. Your apartment will remain rent stabilized after the conversion, but the owner of your apartment will change, and it won't be the owner of the building. It'll be likely what's called the sponsor, right? The sponsor is the former owner of the building who keeps like whatever apartments they can't sell. So when you convert, like you're trying to sell as many apartments as possible. And let's say you're left over with, let's say you have 100 units in a building, right? And you sell 60 of them. There's 40 left. Those 40 are owned by the sponsor, right? And the sponsor is the former owner of the building. And so now when the conversion happens, you're a rent stabilized tenant and you're residing in an apartment that is owned by the sponsor, right? And you keep all of your rent stabilized rights, and you same exact rights you had before the conversion. And the only real difference, there's succession, right? So none of that would change, etc. The big difference, though, I'll say, is that if the landlord or the sponsored in this case can get back your apartment, right, they stand to gain a lot of money, right? Because at that point, the apartment would come out of rent stabilization. And now, as we know, with the HSTPA, no apartments that's rent stabilized can come out, right? So this provides an ability for a landlord to eventually remove an apartment from rent stabilization. And the the that potentially could also be a reason why the landlord might want to buy you out, right? Incentivize you to leave, offer you some amount of money to go. Okay, so that's regulated tenants, right? Meaning if you're a rent stabilized tenant, your building converts, you get to stay, you get to be a rent stabilized tenant, right? So nothing should change. Well, what if you're not? What if you're a market rate tenant, right? An unregulated tenant? Actually, what happens if the building converts under the Martin Act is you get some rights. You get some rights that you didn't have before. And that right would be to stay. That right would be to a renewal lease. That right would be to not an unreasonable rent increase going forward, and only the ability to evict you for cause, kind of like an earlier sort of version of good cause, right? Would exist for tenants, market tenants who live in buildings that have converted to condos or co-ops. Okay, so in general, I think the big takeaway on this is if the owner is going to convert your building, it's not something that should cause a tenant to despair, right? To be nervous, because your rights attach to your tenancy in your apartment, and they're not affected by the conversion, right? Very, very, very important. Um, okay, so I also want to touch on something, right? When I said that after the HSTPA, when it went from 15% to 51% or 50% plus one of tenants that had to buy, right, had to buy the apartments for the plan to be effective, the Governor Hochul this year signed into law what's called the Affordable Housing Retention Act, AHRA, Affordable Housing Retention Act, which for the next 4 years enables condo conversions in specific buildings. I'll talk very briefly about this. It's a little bit in the weeds, right? Specific buildings in New York, um, to convert with only 15% of owners buying, right? And I think the reason why the legislature did this was they saw that there were so few conversions after the HSTPA, right? And so so what happens then is they pass this act, and it allows the landlords to proceed with 15% if there's certain criteria met, right? So it's not every building, it's certain criteria. So the criteria are the following. It's 100 apartments and built after 1996, right? So this is really only going to apply for newer buildings, right? The building can't be part of the Mitchell-Lama program. It can't be owned by a redevelopment company or a limited profit company or other public housing programs, right? So it can't be like an HDFC co-op. It can't be any of like anything where the building's receiving some sort of subsidy, some sort of grant, right? The building must contain income restricted rental units that have been subject to a government program and that have received government assistance. This is important. This would be, for example, the 421 buildings, right? So we've done webinars on 421A. This seems to be taking those 421A buildings and saying, you know what, these might be the good examples of where we should like make more lenient the ability for owners to convert buildings to co-ops. Okay, so it also seeks to potentially, and again, I don't know if I agree with this, but part of the spin, if you will, on this new law was that it would allow lower income or moderate income New Yorkers to become owners, right, and purchase their apartments through this program. Again, this program, I think it was May when it got passed. So, right, we're just talking about maybe 6 months ago. So there's not like a whole lot of, I couldn't really find that much sort of either, sort of studies or analysis or even anecdotal sort of anecdotal tales, if you will, of success or failure with regards to this particular program. Okay, so in sum, that's my take, right? That's my sort of my broad strokes of your rights if your building is going to convert to a co-op or a condo. So, like Jakari said, I want to sort of not speak so much and answer questions and see if we can have some discourse.
Thank you, Jesse. And also, I am allowing the attendees to ask the questions live. If you do want to,
Oh, that's great.
if you do want to come on, just raise your hand. But I'll start with the first question from
Sure.
Anonymous. What legal protections do tenants have when a landlord decides to convert a rental building into condos?
You're right. So the legal protection you have is that if you can sit tight and retain the rights that you have, right? That's the big takeaway from my talk, right? Is that it's not something that's going to again result in your displacement. It's not going to be something you can stay as a renter. You can, right? You can stay as a renter and you can retain your rights.
Next question, are landlords required to give tenants a certain amount of notice before starting a condo conversion?
Yes, they are. There's a process, and it's a legal process. What they're supposed to do is they issue what's a red herring. That's what it's called. That's the legal term. And then after that, they issue what's called a black book, right? And these are the legal terms, right? The red herring, sometimes it's called an offering plan, right? Where they provide tenants in detail. Here's the plan, right? Here's what we want to see happen to the building. Here's what we think 1 bedroom should sell for and 2 bedrooms should sell for. It's a comprehensive plan. It comes in like a bound sort of like book, if you will, and it's delivered to each tenant prior to any sort of conversion, right? You have to provide tenants with that and with notice of that before you can submit to the AG. I think it's 60 days, but I will check and find out. But I think you have to get a copy of the plan. I think it's 60 days before they submit to the AG.
The next question is, what is the difference between condo conversion and a building sale, and why does it matter for tenants?
Yeah, that's good. So a building sale just means that your landlord, whatever that is, so and so LLC, so and so Corp, um, they're just selling it to somebody else. Somebody's buying a building, right? And at that point, your leases will then be issued by and that individual or company or corporate entity, they just step in the shoes of the prior owner, right? And it's pretty much like the same, right? There's no real difference as far as rights or anything at all. A condo conversion is very different. A condo conversion is that the building will now be owned in a very different way, right? There is no owner of a building that's converted to a condo. There is no owner of the building, right? There's owners of individual units within the building, and that's very very different ownership structure, right? It just is. So it's vastly different. Um, Owners do it because it makes them money, right? The owners seek to convert buildings to co-op or cooperative ownership because it makes them money, right? They think they'll make more money selling the apartments individually than selling the building, and or they think that if whatever they don't, they'll sell enough that it makes sense, and whatever it is, then they retain, right? They retain some amount of apartments always at the end. There's never a conversion that I'm aware of in which every single apartment is sold, right? There's usually some remainder that weren't. Those are owned what's called by the sponsor, and again, the sponsor is the former landlord.
Mhm. Next question, do tenants have a right of first refusal to buy their unit before it's sold as a condo?
Depends on the plan, right? So that's why the plan is so important. So a lot of, again, so back to the sort of the beginning, right? In order for a plan to be accepted by the attorney general, right, approved, right? This is not something that unilaterally owners can do, right? An owner can put their 100 unit, their 6 unit, their 8 unit, their 50 unit building on Zillow or Street Easy or whatever it is and sell it. They don't need to go ask anybody for permission. It's like capitalism, like 101. I own a building, I can sell it. Okay. Condo co-op conversion, just different, right? Like you can't just do it. Like you can't say, hey, I want to convert my building to a condo. I want to convert my building to a co-op and just go ahead and do it. No, you have to go through this legal process. And the huge step in the legal process is getting the Attorney General of New York State to approve the plan, to allow this to happen. So there's oversight, right? There's oversight by this law enforcement agency, the Attorney General of New York, over the conversion process, right? So it's back to the question. You got to remember the landlord wants as many tenants as possible to buy. So almost always there will be a price, a sale price in that plan, the offering plan, right? That will be below the market value for that apartment, right? To try to get tenants to jump and take it. Oh, this is too good to pass up. I got to buy this apartment because once I buy it and it converts, then I've made 50% more because I can then, and that's what sometimes happens, right? Sometimes it's an opportunity conversions, right? Again, to be an owner instead of a renter, and to have equity, right? Value in your apartment. So the answer is yes, you get that right to do that, and more than that, the landlord wants you to do it, right? So that's what it is. Yes, but you would have the right to purchase your apartment before somebody else would, right? You would have the right to purchase before like somebody from the outside, or and the sponsor has to give you that opportunity. Like they can't say we're converting, but you don't have a right to buy. You will have a right to buy.
I think you answered this already, but just to reiterate it, can landlords remove rent stabilized units from regulation through condo conversion?
They cannot. A condo conversion will not strip a rent stabilized tenants of their rights as a rent stabilized tenant. You will remain, if you don't buy, right? If you decide you will remain a rent stabilized tenant after the conversion.
It says, next question, what should tenants do immediately after receiving a notice of a planned conversion?
Yeah, great question. So, again, this one is, I think, what tenants would need to do in that situation is seek to um, organize, speak to each other, right? Sort of assess whether or not this is something folks are on board with and wanting, or if it's something that people want to oppose. If you want to oppose the plan, right, speaking to your neighbors, right, making sure, remember these high thresholds now to be able to do it, 50% plus one, right? So almost like a election, if you will, in the building. If you go and talk to your neighbors, vote no, don't vote for the, you can defeat a conversion plan, right? Remember, you need that high number of tenants now to do this. It used to be 15%. It used to be pretty easy. Now it's very hard, right? So I would suggest that you speak to your neighbors and then I think it's again, I think engaging with an attorney is something that probably, again, I'm a lawyer, so I'm not like objective about these things, but I think consulting with an attorney is something very important. It's a legal process, and I think you need an attorney to sort of navigate through the conversion process, no matter how kind of you're going to deal with it. Whether you're going to just remain as a tenant, then maybe might not need as much, need a lawyer, but certainly if you're interested in purchasing, that's something for sure I would recommend you consult and you hire a lawyer.
Uh, the next question, can landlords purposely make conditions difficult to push tenants out?
No, that would be illegal under any circumstance, right? That sounds to me like what the tenant harassment laws are designed to protect against, right? So if your landlord is refusing to perform repairs, if your landlord is intimidating you, right, or constantly, badgering you to leave, right? Those would be textbook examples of tenant harassment. Normally, those are not things that happen to an individual, although sometimes they are. Usually, it's a landlord building wide. So again, that sort of was one of those situations where I would encourage folks to speak with their neighbors, to organize like a tenant association. I think that's the most effective way to take on a landlord who's engaged in some of those, like, some of those types of activities.
Next question is in Spanish, so I'll wait for Daniel to come on.
Sorry about that. Yes, the next question is, what exactly is a co-op? Does that mean that I'm an owner?
Yes, a co-op would mean that, well, yes, if your building converts to a co-op and you're part of the one of the purchasing tenants, then you would become an owner. Yes.
The next question comes from Ashley. It says, friend lived in her apartment for 12 years. One morning, she finds a letter taped to her door saying the building will be converted into condos and she must move out in 60 days. She's scared and unsure if this is legal.
Yeah, so that might be an eviction plan, but that also sounds to me like that might not be legal. I would suggest whoever that is that you send that notice to Palante, and we'll take a look at that and make sure that there's nothing going on. That might just be a landlord just sort of trying to intimidate people into leaving. That's what that might be.
Right. The next question is, heard the convert rate went back to 15% from 51%. As long as the rent stabilization's low income, tenants can get permanent rent stabilization. This is the law change happened this year,
Yes,
2025.
correct. That's right. That's what I was talking about during my opening, right? That there was this change in the law to sort of, I think, to address the sort of the real dramatic drop in the number of conversions following the HSTPA. And now they've changed. And again, like I went through it, I can do it again. It's not every building, right? It's buildings, the biggest ones to remember after 1996, right? So if you live in like a pre-war building, it's not going to be it's not going to be the 15%. They're not going to qualify. It's going to be the 51%. And then also, so built after 1996, or relatively speaking, and relatively new construction, right? And then 100 units or more, right? So you have to live in a pretty big building. 100 units is a pretty big building. So if you're living in a major big building that was built in the last 30 years, then you're building what it's almost likely to qualify for this the 15%, not the 51%.
Thank you. The next question is married couple, only one name on lease. Can this be updated prior to the red herring? Both names to be added on the red herring.
Yes, you can. So, okay, so spouse is the only relationship in which a landlord is legally required to add someone to a lease, spouse. So if you get married and you want your spouse on the lease, you should let the landlord know. And the landlord is then required to add your spouse to the lease. But what that does not mean, and this is a major sort of misconception, it doesn't mean they have to add them to the lease like the day they get the letter, or the week, or the month, or even many months later. All it means is that when the next lease, they don't have to issue a new lease. When the lease comes up for renewal, they got to put the name on. So if you renew your lease for 2 years and the next month you get married, you're going to wait 22 months, right, to get your spouse on the lease. And there's nothing that can be done about that, right? There just isn't. You can't compel a landlord to issue a new lease. There's no law that says that upon presentation of a marriage certificate, the landlord must issue the tenant a new lease. But that's not what it says. It says it has to add them to the lease. So add them to the lease has been interpreted by courts to mean when the lease is up, when you comes to renew, you got to put them on. So it just depends on when the lease is renewed. That's when they would have to be added.
The next question is a bit long, so Jesse, if you want to read on, you can. If you get lost,
go ahead.
Hi, Mr. Gribben. Any thoughts or updates on the trend of Mitchell-Lama rental buildings being actively deregulated by HPD, utilizing a roundabout approach of utilizing nonprofit orgs to acquire the building and then coercing tenants to sign up for Section 8 sticky vouchers? How might this affect a tenant's existing in Mitchell-Lama lease? Buildings are said to still be considered Mitchell-Lama, but rent increases at will and not based on building P&L. It would appear that this arrangement may be done to avoid making the occupied units rent stabilized, as mandated in some Mitchell-Lama leases. Who oversees HPD making sure that they are enforcing guidelines rather than working around them?
Okay, so a very good question. The thing about this, though, is that question that has to do with Mitchell-Lamas, and I think we'll probably have a webinar about Mitchell-Lamas. And I do recognize that what's been presented in that question is a big issue, and there's lots and lots of sort of discussions and things we can talk about with regards to Mitchell-Lama tenants. This is not the topic for this evening, so let's see if we could stay on the topic for this evening, and then we can potentially, I think what we'll do is, based on that question, and is maybe sort of schedule a different webinar that just addresses rights of Mitchell-Lama tenants. I know we've done webinars in the past, solely related to Mitchell-Lama tenants.
Is it common for owners prior to conversion approach tenants with a buyout?
It could be. Yes. I mean, yeah. So the answer to that question, I think, is yes, right? So anytime that there's some sort of contemplated change of ownership, right? Again, why do landlords do this? They do it to make money. Again, we know about 15% or 51%, right, of tenants in occupancy. So obviously buying a tenant out means that apartment's not occupied. So it affects the 51% or the 15%, right? That's one reason to potentially do it. Another reason to do it is if you have lots of vacant apartments, then once it converts them, the landlord can sell them for market rate. So there is a real possibility. Yes, when conversions are contemplated, it's often a time where tenants are approached about buyouts, and that buyouts can be a whole different subject too. Like the Mitchell, we maybe want to talk about that. Buyouts can be seductive, but you got to really be careful, right? Because even if you get what looks like a lot of money, what if they will give you $300,000, right? Like, oh my goodness, which is a lot of money, but it gets taxed, and then if you're spending, if you have a rent that's affordable, Now your rent double, right? Like you'll go through the money like pretty quick. So you got to be everybody should be very, very careful about buyouts and what that means.
This question is from T. Darwish. Are tenants in converted buildings subject to new building policies?
Well, yeah. So good. Yeah. So that's another right. So the ownership does change, right? So yeah, I mean, then you have a condo board or a co-op board, right? So you might have again, if you're a stabilized tenant, though, your fundamental rights don't change, right? But could there be changes in the building, like for like people bringing recycles to different places or packages or like things of that nature? Sure, like they might decide to do like improvements and make a nice lobby or do like those type of things. Those happen all the time, right? The building is changing ownership. Usually that comes with some sort of changes in policies and practices and things of that nature.
Thank you, Jesse. Okay. Question is from Alex. If a building rents to rental, if a building rents to rental apartments, does those apartments count toward the 51% calcium?
If you're asking if like individual rooms in an apartment, no, it's the actual apartments, and it's going to be the apartments as reflected on like the certificate of occupancy or other building records, right? So, like if you're asking if there's like if they created new apartments, like the answer for that would be no. It has to be like the number. It's the number of apartments, like number of apartments registered.
Okay. The next question is from Javier. What is the difference between co-op and condo ownership?
Okay, yeah, I touched on this, right? So co-op ownership is it's a corporation that owns the building, right? So like let's say like Jakari can own a building, right? Or you can have an LLC own a building, right? Here it would be a corporation would own the building. A lot of times it's the name of the building, right? So and so corp. And the shareholders, right? You purchase, it's a corporation, and like corporations, they're owned by shareholders, right? People that own stock in the corporation. So everyone in a co-op building is a shareholder, and you own stock in the corporation that owns the building. And it just so happens that you also get what's called a lease, a proprietary lease, right? An ownership lease, if you will, of your apartment. And the bigger your apartment, the more shares you have in the corporation. That's the way a co-op works, right? So you don't own your apartment, you own shares, right? You're a shareholder of a corporation. The same way if you had shares in like Apple or Google, right? Here you would have shares in whatever corp that owns the building at, whatever Broadway, right? Like that's co-op ownership. Condo ownership, you own it. You have a deed the same way you would have a deed for a house. You have a deed for your apartment 3A, and the building at and there is no like the condo board would own the building, but it's much less centralized, right? And it's a just it there's a lot of advantages to both, right? There's so we could talk about that a little bit. um for co-ops you have to get approved, right, to get like to come into the co-op, like by the co-op board. Condo board, same thing, but condos are a lot less sort of particular about who they kind of let into buildings sometimes. So again, the biggest difference is that in a condo you actually own your apartment, whereas in a co-op you don't. You own shares of a corporation.
Back to Alex. I'm sorry, Alex. The question was, if a building rents to rental apps, like he said, like apps like
Oh, I got you. Yeah, like Airbnb or whatever.
do those apps count toward a 50% calculus? Those units are usually empty, so it's not fair to not count them.
Those apartments would, again though, like if there's no tenant in occupancy, right? The 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 tenant in occupancy would be the one that would have the rights, right? So if it's some entity that's has the apartment that's renting it out, that unfortunately that entity would have the right towards the 50%. They would.
During conversion sale, who can have entry to units for viewing if you are not buying, and how often?
Well, It depends on what stage of the process, right? If it's before the conversion, the sponsor, the landlord, right, was often showing vacant apartments to people, trying to get them to buy. Um, Possibly they could ask for permission to show your apartment to get someone to buy yours, potentially. That's possible too. Um, I don't think there's any like set number on like what they can do to show or not show. I think we've talked a little bit about this different times. You know, the landlords are allowed access to your to apartments, any renter's apartment, upon reasonable notice, right? You can't come knocking at the door and let me in. That's not appropriate. But if they give you what's called reasonable notice, you have to provide access for an inspection for really any reason. I mean, they can't ask for access to harass you, but they can ask for access for any reason. And certainly, we want to show your apartment to a potential buyer would be a legitimate reason, and you would be required to provide access to your landlord in that situation.
Okay, got it. And then the next question is, in an effort to get higher price for sale of units, would owners improve apartment conditions?
Sometimes they do, right? Like, yeah, so that's a good question, right? So that sometimes is what happens, right? Sometimes you'll see quite a bit of investment, right, in a building and individual apartments prior to a conversion, precisely for that reason, right? Again, that's very similar to me to like when a landlord sells. Now, sometimes when a landlord sells, they just sell like this is my distressed property and like but a lot of times like you'll see like little superficial, like they'll paint the lobby, they'll do a little spruce up, right? They try to put the best face on their building. It's not dissimilar to that, right? They like so same kind of thing. Like that does happen. Landlords do some amount of investment in their property, getting ready to sort of proceed with the conversion.
Next question from Anonymous. Can you negotiate the red herring price for your unit?
Sometimes you can, yeah. So I think that's something to keep in mind. Um, yeah, once you get the offering plan, again, this is why some of that question before, what should we do? You, I think the best answer is talk to each other, right? So if tenants kind of like draw the line and say, hey, they offer like 200 for a one bedroom, that's crazy. Why don't we go back and say 150? And if we do 150, we'll tell them like a bunch of us will buy. That might work, right? They might revise and do a second, amendment or amendment to the offering plan and reduce the prices, right? Because they know that will be enough to get them over the threshold they need to convert. So yeah, that does happen.
That looks like that's our last question. Oh, we just got another question that came in. If red herring doesn't meet 50% plus one with current tenants, can they attempt a different way to convert?
No, there's only ways. The only ways to convert a building in New York City are co-op conversions or condo conversions. There's no other manner to convert, and those are legal processes. So there's no way to get around what the law requires as far as what's needed, what must happen in order for a building to convert. That one is not something that's fungible. That has to happen.